Hello and welcome to Matt University's series on meetings. Today we'll be introducing the open meeting law. We'll start at the beginning with the general rules laid down by the open meeting law. We'll then start to get into the weeds a little bit by defining what a meeting actually is and walking through the elements of a meeting for the purposes of the open meeting law. Finally, we'll offer further rating for those of you who are interested. Few laws impact the operation of a local government as directly or as significantly as the open meeting law. Its codification is found in Minnesota Statutes Chapter 13D. All town officers need to develop and then maintain a working knowledge of the requirements of this law. It was born from the idea that public business should be conducted in public, and it requires local governments to do its work at a properly noticed public meeting. These relatively simple concepts can be very difficult to apply in particular situations. It's worth noting that the legislature drafted the open meeting law very, very broadly. It applies not just to the governing board of a local government, but to committees, subcommittees, boards, departments established thereby. In practical terms, this means that not just the town board, but the Town Planning Commission, the Board of Appeals of Adjustment, Joint Powers Board, Park Board, or any other board or committee that the town formally has established must comply with the open meeting law. This introductory video primarily concerns itself with what counts as a quote-unquote meeting within the meaning of the rule. On the surface, this seems like a pretty simple question, but upon closer analysis, it's pretty easy to come up with cases that aren't immediately obvious. Everybody agrees that when the supervisors get together to pass an ordinance, that's a meeting. But what about a situation in which one supervisor, the clerk, and the treasurer are talking about town business? How about everyone together for a retirement party? What about an email chain where a decision on town business is made? How about a situation in which all the supervisors are together and someone just offers them town business related information, but nobody decides anything? Unfortunately, the legislature declined to give us a clear definition of what is or is not a meeting exactly within the meaning of the open meeting law. So it was a bit of a black box that the Minnesota Supreme Court had to grapple with. The quotation on your screen is from Moberg versus Independent School District number 281. In which the Minnesota Supreme Court offered the working definition of a meeting for the purposes of the open meeting law. Quote, "We therefore hold that meetings subject to the requirements of the open meeting law are those gatherings of a quorum or more of members of the governing body at which members discuss, decide, or receive information as a group on issues relating to the official business of that governing body." In the next section of this video, we'll break that down into its basic parts, and we'll talk about each one individually. Now, by my count, there are 5 elements to that definition. We need a quorum, we need voting members gathering together to discuss, decide, or receive information relating to the business of the public body. The first requirement is relatively straightforward and easy to apply: quorum. Minnesota Statute 366.01 Subdivision 1 gives us our general rule. For most townships, that is, townships operating with a 3-member board, 2 supervisors together shall be a quorum. In townships operating under Option A, 3 shall be a quorum. That said, courts will not simply mechanically apply this rule. They can look past the immediate number of people at a meeting to the purposes behind it. Both the Minnesota Supreme Court and the Minnesota Court of Appeals have hinted that meetings that of less than a quorum may violate the open meeting law in certain cases. For example, meetings held to avoid public discussion, to forge a majority in advance, or to hide improper influences all would violate the open meeting law. The quorum and voting member requirements in Moberg reflects the Minnesota Supreme Court's unwillingness to subject gatherings of public officials to the open meeting law where the group lacks the power to transact business. Officers who cannot vote do not contribute to the quorum needed to transact business. Thus, only voting members count under this scheme. The officers must be gathered together to find themselves within the prohibition of this ambit. Now, one caution here, the courts have not dealt systematically with the impact of internet communication on this element. Nevertheless, at present it appears that there must be a, quote, gathering, unquote, to count. What do I mean by that? When O'Keefe versus Carter, the Minnesota Supreme Court faced a fact pattern that's pretty interesting for present purposes. One of 3 members of the Fish Lake Township Board sued the other 2 board members, alleging a violation of the open meeting law. In substance, here was the situation. There were 3 members of the board, O'Keefe, Cupit, and Carter. There was an email chain related to the amount of fuel the township possessed for maintenance purposes. The chain involved Cupit and Carter agreeing to buy more fuel. O'Keefe was also on the email chain, but he did not reply. In an unpublished decision, the Minnesota Court of Appeals held this. Contrary to the implicit premise of O'Keefe's claim, the open meeting law does not apply to written communications between office holders. O'Keefe has not cited any Minnesota case law that applies the open meeting law to written communications, email or otherwise. We are unaware of any such case law. Furthermore, any such case law would be inconsistent with Moberg, in which the Supreme Court suggested that distributing written materials to a quorum of a governing body through the mail, i.e., through the USPS, would not be prohibited by the open meeting law. The distinction between oral communications and written communications is sensible because access to written communications is governed by the Minnesota Government Data Practices Act. That said, unpublished decisions are not precedential. Still, this is the closest we have to guidance from an appellate court about what to do in situations involving email chains. The next element is that the gathering must be to discuss, decide, or receive information. This can be pretty counterintuitive for some folks. Lots of people seem to take the intuitive view that if a decision is made, it is not a meeting. This case was addressed by the Minnesota Supreme Court in 1983 in a case called St. Cloud Newspapers Incorporated versus District 742 Community Schools. The facts are as these. District 742 scheduled and held 4 meetings without public notice. The members of the school board were present, and the superintendent was present, along with certain aides. They discussed school district business at those meetings, things like long-range planning, enrollment decline, transportation funding, things of that nature. This is a quote directly from the Minnesota Supreme Court. The presentation at the meetings were made by school administrators in their areas of expertise for the purposes of providing factual information on topics relating to school administration. The seminar was not directed towards resolving any specific problems of the school district, and no decisions or pre-decisions were made on any issue. Despite the fact that no decisions were made, the Minnesota Supreme Court held that those meetings violated the open meeting law. This is a quote. The meetings which are the subject of the instant lawsuit were scheduled meetings involving all school board members. At those meetings, discussions were held concerning matters which could foreseeably require final action by the board. This type of meeting is within the purview of Minnesota open meeting law. It is not sufficient defense to say that a decision wasn't made. If the gathering discussed or received information relevant to township business, you could potentially be within its prohibition. There's one final element that's critical to a finding that a meeting occurred, and that is the gathering has to relate to the business of the public body. So the quote from Moberg is, quote, chance or social gatherings are exempt from the requirements of the statute. This can even extend to situations in which coworkers are gathering for non-business related reasons. In Berglund versus the City of Maplewood, a federal district court was faced with a situation in which members of a city council were gathering together for a retirement party for one of their members. It held this. A retirement party is a social event and therefore exempt from the requirements of the open meeting law unless a quorum there begins to discuss, decide, or receive information relating to the official business of the public body. That is, just because it's a retirement party doesn't mean that it's necessarily completely exempt, but so long as talk is kept purely social or purely to non-business related matters, you have not violated the open meeting law. Of course, we'll be posting more videos covering exceptions, process, and other details of the open meeting law. But for those who are interested in further information immediately, please see Chapter 7 of the Township Manual available on our website. Thank you very much for your time and for your attention. Have a nice day.